Hello and thanks for joining us on AIT's exclusive law and human rights program, Project Justice. I am Utabel Moran. On this episode, we open from the Nigerian Supreme Court, where one of the most anticipated cases which has generated a lot of public interest is due for a final determination. Specifically referring to the leadership crisis in the People's Democratic Party, PDP. A five-member panel of Supreme Court justices led by the Chief Justice of Nigeria, Walter Onnoghen, on Monday heard and concluded arguments from both sides to the dispute in a packed main chamber of the Supreme Court. Of course, the two main camps to the dispute were fully present.
In my few years of practice at the bar, I have never come across any circumstance in which a respondent to an appeal is purporting to usurp the role of the appellant and withdraw an appeal that has been filed against him. This is a completely new territory, at least to me. So I'm as anxious as you are to find out what the Supreme Court would say, but no doubt in my mind that this will surely add to our legal jurisprudence.
Well, details of that coming in a moment. Also, a major tinkering of the Electoral Act 2010 is underway in the Nigerian House of Representatives. The law which currently governs Nigeria's electoral process, the Electoral Act 2010, is likely to undergo a major review. A public hearing on it held on Monday. About 12 major amendments have been proposed so far. The hearing was declared open by the Speaker of the House of Representatives, Yakubu Dogara. But first, the press segment reflecting highlights of top stories in the law, justice and human rights sector in the past week.
Chief Justice of Nigeria, Walter Onnoghen, has called on Nigerians to report any judicial officer involved in corruption and unprofessional conduct. The Chief Justice of Nigeria was reacting to a media report in which a former senator representing Anambra Central, Uche Okwenefe, accused the judiciary of robbing her of her mandate. Justice Onnoghen challenged the senator to petition the judges involved with relevant proof and urged other Nigerians not to hesitate to do same if evidence exists. He, however, cautioned against unsubstantiated allegations against judicial officers. Justice Sylvester Unguta of the Supreme Court says he is ready to defend himself and prove his innocence before the courts. Justice Unguta is among judges who were arrested in October 2016 following a raid on some judicial officers by the DSS. The money laundering charges against him has been amended 3 times by the prosecution, and trial at the last hearing was stalled due to failure of the prosecution witness to produce relevant exhibits. Trial has been adjourned till Thursday, May 25. The federal government has sought for a bench warrant against the embattled commandant of the Peace Corps of Nigeria, Dixon Akor, and a revocation of a bail granted him. Akor, who is accused of money laundering, recruitment scam, and extortion of funds amounting to 1.4 billion naira, failed to show up for his trial. His lawyer presented a letter craving the indulgence of the court to enable the defendant attend a scheduled examination, a plea which the prosecution argued was too weak. Trial judge John Soho ruled the defendants can be pardoned and adjourned the matter till July 5, 2017. Benue State government has formally outlawed open grazing of livestock, as well as kidnapping and cultism in the state. Governor Samuel Otom has signed 2 bills into law on both matters during a town hall meeting at the Government House, Makurdi. The bill is to prohibit open grazing and promote the establishment of ranches within Benue State.
Welcome back. We now return to the Supreme Court, which on Monday entertained arguments by lawyers representing the two warring sides in the People's Democratic Party, PDP. The battle has been between Ali Modu Sharif, whose legal status as the national chairman of the party has proved the most divisive threat to the survival of the once ruling party and those who want him out. Sharif has a judgment from the Court of Appeal already in his favor. The judgment is a subject matter of the appeal before the Apex Court. It is arguably the most intensely charged political case currently. The outcome equally highly anticipated. Here is what went down at the court on Monday. Another date with the Supreme Court for the People's Democratic Party and its warring parties. Presiding is the Chief Justice of Nigeria, Justice Walter Onnoghen, leading 4 other justices. They are clearly in for business. That as much is made clear when the justices first dispense with the barriers of preliminary motions pending before the court. This involves a request by the Makarfi PDP for leave of the Supreme Court to file its appeal. It is a threshold issue. Arguments are canvassed by both sides, after which the panel takes a short break to confer. Reconvening some 20 minutes later, the justices rule in favor of the Makarfi PDP, formally granting the appellants leave to appeal against the Port Harcourt Court of Appeal judgment on grounds of mixed law and fact. Reading the ruling, Justice Onnoghen and all other members of the panel hold the view that the appeal is deemed duly filed and served. With the ruling in favor of the appellant, leave is also extended to the respondent as regards their respondent's brief, clearing the way for the parties to adopt their briefs on the main appeal. Sharif, through his lawyer Lateef Fagbemi, stands by his position that the Makarfi appeal should be dismissed, as the PDP, which Sharif now controls, never gave consent to anyone to challenge the appeal court decision.
If a man who had no authority to file a process did so, I don't know what justice is there in asking him to go back. That asking him to go back in itself is justice. Don't misunderstand the position of the PDP. It is not the position of the PDP that an appeal cannot be lodged against the decision of the Court of Appeal. Their position, that is the position of PDP, is that they are not interested. If any other person is interested, let him come as an interested party. There is a clear procedure for that. Whoever is aggrieved by a decision other than those involved in that case has the right, if he can establish his right, approach the court for leave to appeal. That is what we are saying.
Can he appeal without a main appeal being lodged?
No. Don't. You see, if you say you want to appeal, all you have to do is to approach the court and say, in this matter, PDP is not appealing. You don't even have to say that PDP is not appealing, that I am interested, and you show how your interest arose or has arisen. By so doing, you can be granted leave to appeal. It is not the position of PDP that you cannot lodge an appeal. What the PDP is saying is that having regard to the decision of the Court of Appeal, which recognized and still recognizes Alimodu Sheriff as the PDP chairman, and having regard to the provisions of the Constitution, which makes provision of the Constitution, which makes Alimodu Sheriff the chairman and by extension the chief executive. He decides whether PDP will appeal. So if there was an appeal lodged in the name of PDP, he has the right to say we are not interested in it. And that is what he has done in conjunction with the secretary of PDP and the National Legal Advisor. You have a look at the constitution of PDP. What it says is that the legal matters is within the exclusive domain of the National Legal Advisor, who appeared in the court below without any objection as representing PDP. So if he has come forward again to say we are not interested in the matter, they are not interested in the matter. But whatever happens, we'll hear the decision of the court whenever it is ready.
We are challenging those who authorize the fight. We are saying, look, the PDP was a party to the matter at the lower court. PDP has the right to facilitate the argument. But for now, don't forget that there are 2 judgments of the trial court, including the Court of Appeal, that says that Alimodu Sheriff, clearly stated that Alimodu Sheriff was the person authorized to appoint counsel to represent PDP. It was clearly stated. And that order has not been set aside. So what we are saying is that who authorized this on behalf of PDP? And they said, look, we have not authorized that. So, okay, you sued in my name, and I have the right to withdraw.
The Makarfi PDP legal team, led by Wallo Lanipekun, submit that the conduct of Sharif's lawyers is a violation of the rules of professional conduct. He urges the court to uphold their grounds and allow the appeal.
The Supreme Court of Nigeria has had the appeal and judgment has been reserved. So that's all. And let us also commend the court, because in appreciation of the importance of the matter, the court within these 3 months that judgment of the Court of Appeal was given, briefs have been filed and exchanged by parties, and the Supreme Court, presided over by the Honorable the Chief Justice of Nigeria, sat today. It's taking all the arguments, all objections, taken together with the substantive appeal, and judgment of the Supreme Court has been reserved. I think that's all. We can't be re-arguing what we have said in court on the screen. It's not done, it's not proper. But that's all I can just tell you. What I said in court, I cannot repeat it here. But the summary of what has happened is that appeal has been taken, judgment has been reserved. Let every party await the judgment of the Supreme Court of the matter.
As the parties depart, the implications and significance of the outcome is clearly not lost on them.
First is about speedy dispensation of justice and the attitude of the Supreme Court, not just to this matter but to all matters, as you might have discerned, is to expedite matters so that they don't get delayed. But in this particular case, national importance is implied. The future of our democracy is implied. The virility of the current democratic dispensation is implied. An opposition that is weakened certainly cannot be meaningful to the good development, good governance that we all crave for. So it is in the interest of the whole Nigeria that the PDP situation should be justly and quickly be determined. And there is no better place to have that than at the apex court. This is leading by example, as far as I can say. This is the Supreme Court leading from the front, telling the other courts lower in hierarchy that matters of this nature ought to be dealt with quickly and speedily. And that is what I think we are witnessing. I don't think any of the parties on the right or left could have asked for anything more than the way this matter has been taken. And now all the arguments are in, and it's now for judgment. Both sides have agitated their points. The Supreme Court would obviously take a decision as to whether they agree with those who say there is no authorization or disagree. But one clear point is this: there is a decision by the Court of Appeal, and that decision is appealable. The people who took the case to the Court of Appeal sued a party. The appeal was against a party, a person, and that was against PDP. Senator Alimodu Sharif filed appeal against PDP, and the judgment went in his favor and against PDP. Now, PDP, exercising his own right of appeal, has further appealed to this court against that decision of the Court of Appeal. Now, here in the Supreme Court, the same people who sued PDP and got judgment in their favor are suggesting to the Supreme Court that no, PDP has no right of appeal. Or at least if it has, they, being in control of PDP, have the right to terminate that appeal without the Supreme Court hearing it. These arguments that have been submitted to the court will decide whether they agree with them or they disagree with them.
I've heard senior counsel argue that this is a very narrow precinct, that there's really no precedent on it at all. How much would this decision advance the course of jurisprudence in Nigeria?
It is a narrow point. It is a novel point. In my few years of practice at the bar, I have never come across any circumstance in which a respondent to an appeal is purporting to usurp the role of the appellant and withdraw an appeal that has been filed against him. This is a completely new territory, at least to me. So I'm as anxious as you are to find out what the Supreme Court would say. But no doubt in my mind that this will surely add to our legal jurisprudence.
Thank you.
The next time the warring sides return to these courts, there will be no doubt as to their status and claims to the control of the People's Democratic Party. The significance of this case perhaps necessitated the urgency attached and the expeditious nature in which the Supreme Court has decided to dispense with it. It was earlier fixed for Thursday, 25th of May, but had to be brought forward to Monday. Of course, with an election timetable for the 2019 general elections already out as released by INEC and governorship elections in Anambra by November 2017 and Ekiti after that, there is a heightened need for certainty in the PDP after the losses encountered by the party in Edo and Ondo states, notable casualties of this lingering leadership dispute. Now let's talk lawmaking. We told you earlier that the House of Representatives has begun an amendment to the Electoral Act 2010. Here is what you need to know about what areas are up for review and the new provisions that have been proposed. There are 12 major amendments in the bill, which has passed second reading. These are a bill for an act to make provision to cover the lacuna in the event of death of a governorship candidate any time before the conclusion of an election. Also, there is a bill to amend the Electoral Act 2010 to empower election tribunals and courts to declare candidates who scored the second highest vote as winners of election when the tribunal or court finds or holds that the winner of the election is unqualified for the election ab initio. A bill for an act to ensure that all political parties are gender sensitive and to eliminate all forms of discrimination in all political parties. A bill for an act to include the use of the card reader as part of the act and clearly specify the tenure of the office of the Secretary of INEC. A bill for an act to increase the amount permitted as maximum election expenses to be incurred by candidates standing for elections. A bill for an act on nullification of election by tribunals or courts and for other related matters. A bill for an act to amend the Electoral Act 2010 to make the electoral process foolproof by making the card reader the credible means of voter accreditation and voting and provide for strict compliance with election guidelines and manual so as to enhance transparency and efficiency in the conduct of free, fair and credible elections. A bill for an act to amend Section 33 and 36 of the Electoral Act 2010 to provide for death of a presidential or gubernatorial candidate during an ongoing election. A bill for an act to amend the Electoral Act, Cap E6, Laws of the Federation of Nigeria 2004, to incorporate diaspora voting in the presidential election in the Nigerian Electoral Act 2010. A bill for an act to amend the provisions of the Electoral Act, Number 6 of 2010, to provide a timetable for submission of list of candidates, criteria for substitution of candidates, disclosure of sources of funds contributed for political parties, and to empower the Commission to uphold party primaries where there is a change in the results and for other related matters. A bill for an act to establish the Electoral Offences Tribunals for the purpose of trying electoral offences. A bill for an act to establish the Nigerian Electoral Offences Commission, charged with the responsibility of prohibition and prosecution of electoral offences and for other related matters. As noted by the Speaker of the House of Representatives at the opening of the public hearing, the whole idea is to engender public and citizen participation in the electoral process.
The 12 bills before us this morning seeking to amend the Electoral Act are a consequence of our election experiences as a nation, including the 2015 general elections. Experience has shown that good electoral system governed by an efficient and effective legal framework is an inescapable prerequisite for the conduct of free, fair, and credible election. The government derived its authority from the consent of the governed. And the only way that consent of the governed will be translated into governmental authority is through elections. Now, all democracies hold elections. Even pretending democracies, those who are nominal democracies, democracies by name, they hold elections. But not all elections are democratic. And for an election to be qualified to be democratic, certain criteria must be met. The elections must be competitive, they must be periodic, they must be inclusive, and they must be definitive. Now, any election that doesn't meet these criteria, even though it is called elections, will not qualify as a democratic election.
We are all witnesses that the 2015 general elections organized by INEC were remarkable and indeed substantively much better than previous elections. They represented a turning point away from the history of badly conducted elections towards the satisfaction. They represented a turning point away from the history of badly conducted elections towards the satisfaction of the aspiration of Nigerians for free, fair, credible, and peaceful elections. The determination of the Nigerian people to build on the gains of our democratic achievements manifested in the votes of the last general elections that saw to the voting out of an incumbent government and replacing it with the main opposition party, the All Progressive Congress, APC. However, while we acknowledge that the 2015 general election was a milestone in Nigeria's democratic evolution, there is no doubt that there is still a lot of work to be done to take the country to the point where elections are devoid of the usual challenges of violence, fraud, and abuse of process. A review of the 2015 general elections indicates the need for the National Assembly to take legislative steps to address identified challenges and block the loopholes encountered with the conduct of the elections.
INEC recalls that during the retreat of the House Committee on Electoral and Political Parties Matters in May 2016, the Honorable Speaker promised that the House will consider and pass required amendments to the Electoral Act well ahead of the 2019 elections. INEC has released the election calendar for 2019 general election and other general elections going forward. Following broad and extensive consultative processes and engagements, the Commission has approved the proposed strategic plan and strategic program of action for the period 2017 and 2021. Consequently, the Commission constituted the Election Project Plan Committee to commence forward planning for the 2019 general elections. INEC has commenced the continuous voter registration exercise CVR in all the 774 local government areas nationwide. This is the first time in the history of elections in Nigeria that INEC is embarking on a continuous registration of voters in the manner prescribed in the Electoral Act. We urge the honorable members of the House of Representatives to please sensitize eligible citizens in your constituencies in the need to register to vote.
Since the inception of electoral changes in this current administration, parties as major players are not being brought to table to discuss major issues that affect electioneering in this country. But we thank God the House of Representatives have today extended the gesture to us. We are very, very happy for giving us this opportunity to be here to discuss and present our memoranda on how to move political development and electioneering forward in this country, Nigeria.
We urge that this support continues and indeed that efforts at amending our laws for elections happen even before the House takes the summer break in July.
Of course, what is expected to follow is a robust engagement with experts on the essential details of the bill. Many of the proposals are as a result of apparent lacunas observed in the 2015 general elections. For instance, if the proposals are passed, the card reader will receive legal backing and become the only legitimate means of voter accreditation. Remember that after the 2015 elections, the Supreme Court held that non-accreditation of voters with the use of the card reader is not enough to invalidate an election or as a basis challenge an election, as what is expressly provided for in the extant electoral law is manual accreditation. So the card reader was provided for only in the manual and electoral guidelines issued by INEC. Of course, there was the argument that INEC is a constitutional creation and so empowered in the third schedule to the Constitution to issue guidelines to effectively carry out its mandate. An argument which, well, failed to hold weight before the interpreters of the law, that's the judiciary. There is also the provision for a death of a candidate before, during, and after an election. That too became expedient after the situation in Kogi State. Well, Project Justice will, in subsequent episodes, take up the various aspects of the proposals in detail. And that's our show this week. Remember to follow us on our Twitter handle. It's @ProJusticeLive. Also like ProJustice on Facebook and view us also on YouTube. And on behalf of the entire production crew, I am Utobau Moran. Thanks so much for staying with us.